The statute requires mediation in Tennessee because I think that our legislature and our judiciary realized that we don't have enough judges and enough courtrooms and enough time to litigate every single issue in every single case. That mediation, it serves judicial economy, it saves time, it saves money for everybody. It's less acrimonious, so there's less of a mental, emotional toll. And so I think it's a public policy decision that lawmakers just decided mediation is the better way to go instead of two parties in a divorce or in a civil action going to battle and throwing stones. You know, I always tell people, if you're going to sling mud, you're going to get dirty. And whatever you're saying and doing to them, they're going to try to say and do to you. If you go to mediation, and let's say it doesn't settle, one of the things you'll learn in mediation is what are the issues that are really motivating the other party? What do they care most about? What did you spend most of the time at mediation talking about and arguing about with the mediator going back and forth? And you can also sometimes solve some of the issues, but not all of them. Some attorneys, some parties like to be all or nothing. And when I was a younger lawyer, I used to sort of be pig-headed and all or nothing like that. But as I've gotten older, I realized I want peace and serenity and I want things to be a little bit easier. And I think if you can settle 8 of 10 issues and you only go to court on those 2, it lets the judge have more of a rifle approach on those 1 or 2 issues and devote more undivided attention to that instead of you've got all 10 issues to litigate and it's a scattershot or shotgun approach. So I think that there is, if something like custody or alimony is the issue you can't settle in the mediation, settle everything else and then just go have just a custody hearing or just an alimony hearing. It's going to save time or money. You can probably get an earlier court date because you don't need all day or 2 days or 3 days or 5 days. So that's some of the benefits of mediation that parties don't really realize. I hear some attorneys say it's easier to try a case than it is to settle it in mediation. I totally disagree with that. That's only true if you don't prepare for trial. And I always prepare for trial. And if I'm preparing for trial and spending my time on it, the client's spending their money on it. And I try to prepare for mediation. You've got to be prepared for that mediation to give it the best chance to settle. You fill out the mediation paperwork that the mediator sends you. You lay out the facts. You lay out the issues that are going to need to be decided at mediation, and you send over a proposed MDA and a parenting plan so the mediator's got a place to start, and there's no excuse for them not to reduce any agreement to an MDA or to a parenting plan because they've already got the skeleton there with most of the meat on the bones, and they've just got to go in there and any issues that were mediated and compromised, make those brief changes and get everybody's signatures, and we're done.